again. I think trying to figure that out. Could I have everyone mute if they haven't already done that? So let me begin again. Welcome, everyone. We began this series during the heart of COVID, and I wanted to say a special thank you to Shala, the director of the Hong Kong U LLM ADR program, and Grace Ip, one of our alumni, for orchestrating this series. My name is Saniza Othman, and I'm chair of the Hong Kong U LLM ADR Alumni Association. Today's webinar is called Paying for Arbitration, and we're pleased to have Caroline Thomas here today to share her insights. Caroline is a lawyer and arbitrator based in Hong Kong. She is a consultant to Hugill and Ip solicitors. Her industry sectors include being a regulatory lawyer, reinsurance, shipping and trade, energy, telecoms, tech, pharma, and construction. She has extensive experience of about over 50 cases as counsel and arbitrator in international arbitrations. She holds an LLM focusing on arbitration from Columbia University with honors. She is a fellow of CIARB, and she's listed on numerous arbitration panels and lists, including HKIAC and Hong Kong Mag in Hong Kong. After several years at a leading insurance and international trade law firms, including as partner, she spent several years in senior legal and policy role at the Insurance Authority of Hong Kong. She's on the board of various institutions, including Hong Kong Insurance Law Association Limited, RES Asia, and CIARB East Asia branch. A couple of housekeeping matters, please. Please, could everyone mute your microphones, please. The format of today's talk is Caroline would present for 50 to 55 minutes. It'll be followed by a short Q&A. As you're listening, please feel free to type up your questions into the tab so I may collect and read them out. Without further ado, the floor is yours, Caroline.
Hi, welcome everybody. Thank you so much, Saniza, for the really kind introduction. Thank you also to Shala, Grace, and Tammy, and HKU. As Saniza mentioned, I did my LLM. In fact, that was part of my COVID plan, and I loved it. So I'm really excited to be having the chance to talk to LLM students myself. Now, just to let you know, you will subsequently get my slides, which are completely packed, so don't feel like you have to write everything down. What I'm trying to do is merge lots and lots of different ideas I've had basically over the past few years, talking to people in different jurisdictions and just trying to get my head around this whole concept of paying for arbitration and where it's going, because there's really a lot moving, and it's moving very, very fast, but at the end I try and tie it all together. So there's a couple of things on the agenda. First of all, I'm just going to outline the ways to pay for arbitration. Secondly, I'm going to look at the backgrounds, the history, which I actually found quite interesting. And, you know, I'd always heard of champerty and maintenance, but I drilled down a bit further back in time. Then I'm going to look at the key hubs for arbitration and sort of in chronological order. So starting with Australia, then Europe, then the UK, then the US, then Singapore, Hong Kong, although they're chicken and egg, they're kind of around the same time. Then ISDS, which is investor state arbitration. Then I'm just going to give you some names of the players. There's more of them. And then I'm going to try and tie everything together in some kind of summary and trends. So arbitration can be expensive. In fact, as many of you've probably heard, arbitration sometimes can be even more expensive than court proceedings, although it has several advantages, notably the New York Convention and confidentiality. So basically, there's three different ways a company involved in an arbitration as a claimant or as a claimant or a defendant can finance it. One, they can basically go to their own pockets, so their own funds. Two, they can look to their lawyers. And three, they can look at funding from a third party. So starting with looking at their own pockets, so companies, individuals, and sovereign states will have a balance sheet. They will have money of their own. Law firms too might be involved, and that's a point I want to make, which is that you may have different options for financing, but they kind of interact. So law firms sometimes have agreements with litigation funders to fund several cases, a kind of whole portfolio. So that's why I put law firms there. Lawyers increasingly have options to help clients. So you're probably all familiar with pro bono. That's working for free. That's probably not long-term viable as the only way of financing clients. So there's also conditional fee arrangements, which is when the lawyer charges discounted fees but gets an uplift if there's a success. Then there is something slightly different, which is a contingency fee, which is the lawyer fronts the fees, all or part of them, to be repaid if there's a success. And normally the repayment is a share of the award, so that's the percentage. And then the third category is third-party funding, which there has always been in some form, but that is really developing a lot. So a simple form of funding is a loan. Another form of funding is you can actually sell your claim, or you can assign your claim to someone else who can take it over. So if you don't have a lot of cash, that's something you might do. A claim is an asset. Then there's always been insurance. So for example, I've worked in the maritime space for a long time. So I've worked for a lot of P&I clubs, and they will typically handle claims for ship owning. So there's lots of different kinds of liability insurance. There's also D&O cover, etc. So there's liability insurance, there's before the event insurance, and then there's also something relatively new where there have been actually lots and lots of presentations in the recent few years about this product. It's called after the event insurance. And that's quite interesting. That's where legal costs and legal costs orders are paid by the insurance company. And the weird thing about it is that the insurance premium, so the amount of money you pay for the insurance, is only payable if you're successful. So that's slightly quirky. And then, and this is the most important thing, we have third-party funding increasingly in jurisdictions across the world. Here is a sort of controls scheme that I found in one of my own LLM materials, but I've adapted slightly. So it just looks at these options and tries to illustrate in terms of client control and funder control who has control. So obviously traditional insurance, but also assignments of claim, the clients tend to have less control depending, for example, on what the insurance says. If you assign a claim, obviously somebody else completely takes over. And then on the other extreme, you have third-party finance after the event insurance and before the event insurance, where again, depending on the terms agreed, the funder tends to have higher control. And this is something interesting because you end up sometimes with a conflict of interest between what the funder or the insurance company wants and what the client wants. And this is something I've always been conscious of acting, for example, for P&I clubs and ship owners, because sometimes there's a tension. And what I've learned, and this is the text in red in the top right-hand corner, is that there is a difference in philosophy between some of the different funders. So apparently the European funders take slightly less control than US, UK funders. Now, third-party finance is actually a difficult term to define. And there's lots of different definitions that I found. So I've just crystallized a relatively simple one, but it's an agreement by an entity that's not a party to the dispute to provide a party, an affiliate of that party, or a law firm representing that party with finance, basically. So the background to what's been going on recently is basically a prohibition. I took a poster from the prohibition of alcohol in America, but that's not really the prohibition we're talking about. The prohibition we're talking about is against maintenance, champerty, and barratry, which are historical crimes and torts. And you find these basically in a lot of common law jurisdictions. So maintenance is the meddling by a disinterested party in a lawsuit with which they have no connection or valid interest without just cause. Champerty is aggravated maintenance where the stranger has a financial income in the outcome, and barratry is continuing practice of maintenance or champerty. So as mentioned, these were crimes, and in some jurisdictions still are crimes and also are torts. And these prohibitions have basically meant that lawyers traditionally in common law jurisdictions have not been allowed to offer contingency fee arrangements. There's another quirk that is relevant, which is usury. So usury is, well, it's basically the Merchant of Venice. High interest is not allowed in many jurisdictions. And so this is where I got interested, because I always thought champerty and maintenance must be something English. Well, it turns out that champerty and maintenance have an even longer history. They come from the Greek and Roman law systems that developed it. And then basically in the ages of feudalism and empire, maintenance and champerty doctrines spread and developed across basically the British Empire. There's a case in the UK in 1883. I've put down the name in case you want to look it up. And then we start getting some major changes. So in 1967, champerty and maintenance were decriminalized in the UK. But be careful here, some people get this wrong. There's still a tort. And that then continued until major reform in 2007, where the UK Civil Justice Commission held that properly regulated third-party funding should be okay for mainstream litigation. However, at the same time, in Hong Kong, there were several cases, and one key case was the Unruh versus Seeberger case in the CFA, which basically held that champerty and maintenance were alive and kicking in Hong Kong, possibly also in arbitrations. So basically, when I started training as a lawyer in Hong Kong, the general view is you absolutely cannot do that. And in fact, in 2012 in Hong Kong, there was the case that most law students will be familiar with, which is Winnie Low versus HKSAR in the CFA again. And that was a criminal case, and that held that it's still a criminal offense, punishable by 7 years imprisonment. And then we get to 2015, and that's where changes start to be implemented in Hong Kong and Singapore, which of course are both jurisdictions which are arbitration hubs and indeed trying to stay on top and on the forefront of arbitration laws. So I just turned this into a timeline, which then hopefully also explains why I'm dealing with jurisdictions in the order that I'm dealing with them. So Australia kind of starts this process. Germany is next. UK, US, Hong Kong, and Singapore. And I haven't mentioned other European countries, but I think as we've just seen, champerty and maintenance are issues mainly in common law jurisdictions. And obviously there are many countries of the world that are civil law jurisdictions, so they don't perhaps have the same issues that we've had. But the main arbitration hubs of the world tend to be common law jurisdictions, which is why I've focused on those jurisdictions in this presentation. So how does third-party financing work? And what are the options for a claimant? So basically, for a claimant, the funder will step in to pay the claimant's own costs, or some of the litigant's own costs, with the remainder being on a CFA basis, so conditional fee arrangement, or after the event insurance. And I just want to highlight this because apparently Saniza received a question about, which financing option do you choose? And I think I'd like to underline that it's not one or the other. You can actually have different financing options. And I think some financiers actually like it when the law firm itself also has some skin in the game. And then obviously you can couple that with after the event insurance to cover some of the costs. So you can create something complicated. I've also outlined what happens with adverse costs. So if there are any adverse costs against the claimant, which you typically get, not in all common law jurisdictions, but you certainly get it in England, Hong Kong, Singapore, the funder will pay the adverse costs, or some of the adverse costs, or you can, again, bring in insurance to cover the adverse costs. So again, to underline, you can have several different financing options that interact to cover the whole thing, or you can have one or the other. And of course, the funder wants to receive something. So normally they get the commitment in terms of money times a multiplier, and or cash in terms of money times a time multiplier. And oh, I'm blocking those slides. Sorry, need to move this. Or a percentage, right? And similarly, third-party financing can work for the defendant. It's slightly different because, of course, the defendant is being attacked, so the funder would pay the defendant's costs. Also, adverse costs if the claimant wins. Also, damages if the claimant wins. In exchange, the funder would typically receive reimbursement of costs, a percentage of damages if the claimant fails. And then I think that the general important point is to know, depending on how well the defendant does, so here we're talking about reducing the claim, the more the funder gets. So as discussed before, third-party financing can work in different ways, and it can be coupled with insurance and lawyers putting conditional fee arrangements or contingency fee arrangements in place as well. You can do it for one case, so an individual matter, but you can also do it for portfolio financing. So for example, a good friend of mine based in the UK works for a litigation boutique, and they have an agreement with a funder that I will not name, whereby they fund an entire portfolio of cases. Now, the nice thing about portfolio is you pool the risks, and because you pool the risks, you can sometimes reduce the cost. There's, again, as I mentioned, an interplay with damage-based agreements and ORFSA, which is the Hong Kong outcome-related structures of arrangement. The reason third-party financing is often used is to monetize things. So it provides finance for working capital against the outcome of a claim. So companies need money, and so third-party financing can basically free up their balance sheets. And as we discussed before, sometimes assignments work, and third-party financiers sometimes actually outright purchase disputes. So there's different ways of doing it. Now, the typical claims that are funded through third-party financing include insolvency claims, investor-state arbitration, where the numbers are just huge. I mean, at a minimum, I think somebody once said 4 million. I think you're actually often looking at a lot more for such a claim. Class actions are very typical. We'll see that when we look at Australia, but also the US. Anywhere that has a class action framework, litigation finance tends to get involved. So investor claims, I did a whole course at Columbia about securities litigation, and there seems to be something similar going on in Australia. Tort claims, very, very typical. So for example, Dieselgate, competition law. I just attended an event earlier this week by the Competition Law Association, and somebody was saying, why aren't there class actions in Hong Kong to basically facilitate follow-on actions which already exist in some jurisdictions? That works. And then big corporates sometimes look at third-party financing just because it's a way of freeing up their balance sheet and using their capital for something else. A risk which I want to underline, and this is something we looked at during one of my arbitration courses at Columbia, is when you are giving information to a financier to try and get financing, you give a lot of information, and that risks waiving privilege. Privilege is something that is very specific to the jurisdiction you're in, so it depends on what rules apply, but that is something that you have to take quite seriously and be quite careful about. So let's start with Australia, where I think the story does start. So maintenance and champerty were abolished as crimes and torts in some states, such as New South Wales, Victoria, South Australia, and the Australian Capital Territory. Recently, there was a development in Queensland, so last year. In the mid-1990s, there was also legislation introduced that allowed the financing of insolvency litigation. And that makes sense because, as we've also seen in Hong Kong, an insolvent company that, for example, has suffered as a result of its directors' wrongdoing has no money by definition to pursue these claims, even though they might be good claims. So financing for insolvency situations has always been on the cards in many jurisdictions. In 1992 in Australia, the federal government allowed reforms, including class action procedure and other measures to increase litigation, including a form of conditional fee arrangements with a limited uplift, namely 25%. It turns out that was not very attractive to lawyers, and contingency fees were not allowed. So remember, we discussed the difference between conditional fees and contingency fees. What basically then happened is that third-party financiers stepped in to fill the gap. There was also a case called Foskey, which we'll look at in the next slide, that was basically the high watermark, I think, for litigation financing in Australia. It basically confirmed it's all right. There's also something that changed, and I recently really understood what happened, which is that in 2020, in Victoria, it became possible for lawyers representing a lead plaintiff in a class action to get court approval and then to recover a contingency fee. And there seems to be a lot of action, particularly in the state of Victoria, in terms of class actions in Australia now. So as mentioned, Foskey was a high watermark. So between 2006 and 2020, the funding industry in Australia grew massively, and there were few restrictions. There were actually exemptions from regulatory requirements on policy grounds. And I think we'll see that later on. So this is something that's also happening in Europe. On the one hand, from time to time, there are scandals. On the other hand, legislators want to encourage consumers, for example, to be able to protect themselves, for example, through class actions. And so they need money to finance that. So that's what's happened in Australia. They had a free hand. But then in 2020, in Australia, there was legislation requiring funders basically to get licensed and to comply with managed investment scheme arrangements. Then there were further regulatory requirements proposed, basically trying to limit how much a funder could get out of a class action. So they were saying at least 70% should go to the members of the class, i.e. not to the financiers. Otherwise, the financing shouldn't be approved by the court. But there's been a lot of basically changes in government in Australia, and there was a reversal last year. So that was reversed. So they no longer have to comply with MIS. So there's, I think what's happening in Australia is moving quite a lot, and we need to watch this space. There was actually, I believe, a fairly big scandal in Australia. So that, I'm a regulatory lawyer, so one thing I do notice is every time there's a scandal with legislation, then there's pullback, and then there's maybe another incentive to go the other way, and there's another scandal, and there's more regulation. That's the way regulation generally tends to happen. Now, turning to Europe, which was the next jurisdiction really on the timeline, it's worth underlining again that most EU jurisdictions have civil law and not common law. So common law really, now that the UK has Brexited, is Ireland. So that means that few EU member states have champerty and maintenance, and few therefore prohibit third-party funding. Greece and Ireland, which is the common law jurisdiction, are outliers, and I understand that the prohibition is currently under review in Ireland, with something to come in 2024. In most other EU countries, there is actually no legal framework. There have been third-party funded cases, and I've spoken to a financier basically in the 2000s in Switzerland. Some countries regulate it a little bit subject to licensing, that's Norway and Italy, but they don't restrict it as much as, say, what was proposed in Australia. And there have been a lot of third-party funded claims, for example, from Germany. However, there is a bit of movement. So, and this is where it's quite interesting to look at the bigger picture. So I understand that some regulators were looking at what was going on in Australia, remember the scandals, and thinking about whether things might have to be regulated. So pre-COVID, this started in the EU by a German MEP. And in late 2020, there was an opposite tendency, namely the Parliament issued a directive on collective redress. So that's basically trying to introduce class actions. So on the one hand, they're looking at, okay, there's scandals. We need to maybe regulate it. On the other hand, we want class actions, so we need funding. So this is quite interesting. And what I have heard informally is that in summer of this year, there was a closed meeting with one of the basically industry bodies. It's called Alpha. We'll look at it later. But the commission basically said, actually, they are focusing on consumers defending rights. And I've also heard that subsequently the EU Commission has said that they probably won't regulate third-party funding if there are no major scandals. So it seems that there isn't likely to be regulation in the EU, but watch that space because it always depends on whether there is a scandal and also whether somebody really tries to move things. In England and Wales, the framework has changed quite a lot, basically since the 1990s. And here we also have a similar trend. So they start looking at, well, access to justice. If you want access to justice, you need to relax things like champerty and maintenance and allow third-party financing. But then you also have countervailing trends. So in 2012, they abolished the recoverability of after the event premium and conditional fees. So you keep having this pendulum swinging one way and then slightly the other way. It's kind of correcting. In 2023, there were damages-based agreements regulations. These prescribe the requirements with which damages-based agreements, so this is basically lawyers allowing to take a cut of the winnings, must comply in order to be enforceable under the Courts and Legal Services Act 1990. But it's not just lawyers, it's also third-party funders that have to follow this DBA regulation. And this becomes very, very relevant. We will see that in 2 slides. We also have other developments in the UK. So from 2007, basically the Civil Justice Commission looked at alternative financing structures. In 2010, there was the Jackson Review of Civil Litigation Costs. In 2011, a Code of Conduct for Funders was issued by one of the industry associations. It's called ALF, the Association of Litigation Funders. It's been updated. The Queen Mary Task Force issued a couple of reports, one on security for costs, one on third-party funding. These kind of look at best practices, specifically in arbitration. Queen Mary is, of course, a top arbitration university these days. And then we come to this year, which is where the DBA that I just mentioned becomes very relevant. And there was a Supreme Court decision in a case called Packard that basically all the funders are talking about. And basically it says that third-party agreements with third parties who play no part in the conduct of litigation but are paid a share of any damages recovered by the claimant are damages-based agreements, or DBAs, within the meaning of the relevant legislation, which we just saw. And the crux of it is, if they don't comply with the DBA regulations, then these kinds of agreements are completely unenforceable. There is a case which is very new, where a funder basically has applied to the High Court for its part in the outcome of an arbitration. And there's been cross undertakings. And I think the point was they were resisting fortifying these cross undertakings. And the High Court agreed that there's a serious question to be tried. I mean, the question here is, whether a lot of funding agreements are unenforceable in light of PACCAR. And it depends who you talk to. Some funders say yes, and some funders say absolutely not. And if they're unenforceable, can you basically delete the relevant question? So can you sever it from the funding agreement, or is it otherwise irrelevant? Or does the whole funding agreement fall over, which then means that the funded party can renegotiate? So this is really, really interesting. It sounds like the High Court may not take down the whole thing, but we shall see. In the US, very similar. It's state by state, so it's kind of like Australia. So some states have basically said they don't recognize champerty or maintenance, and others kind of say they're completely out of date. I've listed the ones which don't recognize it. Litigation funding has also been challenged as usury in some states. So there's some cases in New York where this has happened. There's also an issue in the United States. There are these model rules of professional conduct which exist for the whole of the US, and they kind of get copied and adopted state by state. And Rule 5.4 basically says a lawyer cannot share fees with non-lawyers. And there is a push to modify that, and some jurisdictions don't accept it. There's issues, and those are the issues that I looked at when I was at Columbia, to do with privilege and waiver. In the US, there's a thing called common interest privilege, which can sometimes cover the information that a party gives to a funder. But it's very important to be very careful about how information is shared. And it can also be helpful if the litigation is initiated before the exchange of information, because of when these privileges start. Also interesting, there seems to be a trend, and I think we'll see it in many jurisdictions, to the disclosure of litigation funding. So you kind of have to tell your opponent, and you have to tell, if you're in arbitration, the tribunal that you're being funded. And Wisconsin was one of the first states to require litigation funding in commercial litigation. So they had a law in 2018. And I think that makes sense. If you're being funded, the trend seems to be that the funding has to be disclosed. Now we're starting to look at Singapore and Hong Kong. They started to change their frameworks at roughly the same time. So as you remember, we had champerty and maintenance, absolutely no funding at all. In 2017, the Civil Law Act in Singapore was amended, and civil law third-party funding regulations were enacted in the same year to allow third-party financing in international arbitration and related court and mediation proceedings. In 2021, that was widened slightly, notably to include domestic arbitration and also proceedings before the SICC. Oh yes, and the other point to note is, as I mentioned, insolvency proceedings, very important, and liquidators need access to funding. So that has also been allowed since 2015 through a specific act, which was introduced in 2018 and entered into force in 2020. So it's very, very similar to what happened in Hong Kong. And there's sort of limitations on funders and what they need to do. There is also a code of conduct in Singapore. As I mentioned, the trend seems to be for the disclosure of third-party funding. Now, where you find that is in the rules. So the SIR, these are the investment arbitration rules. So the SIAC investment arbitration rules, I think, draw upon quite a lot the ICSA arbitration rules. I think SIAC is one of the first arbitral institutions that issued investment arbitration rules, and it gives the power, gives tribunals the power to order disclosure of the existence of third-party arrangements and/or the identity of the third-party funder, and/or where appropriate details of the funder's interest in the outcome of proceedings, and/or whether the funder has agreed to be liable for adverse costs. I think that's actually extremely wide. So Singapore did this actually before ICSID changed its own rules and did something similar. We'll have a look. I think they did that last year or the year before. There is a consultation underway in Singapore on the rules for commercial arbitration. This consultation is open until later this month, and actually SIAC is holding an event on Monday to discuss it, which you may be able to sign up to. I find this particular clause which they're introducing, so 38, quite interesting. I think it goes quite far. And here, 38.3 specifically, basically, I think it's obvious that the funding arrangement needs to be disclosed, because if there is a funder, that might lead to conflicts of interest, and those conflicts of interest need to be laid bare so that, you know, the tribunal doesn't have a conflict of interest, the parties don't have a conflict of interest, counsel don't. But 38.3 goes a bit further, and I do wonder whether it's going a bit far. So I'll just put that out there, and maybe some of you want to respond to SIAC, which is consulting. In Hong Kong, we are doing pretty much what Singapore is doing, except that we've had third-party funding for insolvency proceedings for a very long time. I think that comes from case law. So I always thought it was Judge Harris, but I think it actually predates Judge Harris and goes further back. But the courts have always been pragmatic and said, look, a liquidator will need funding. It's always been allowed with court approval. What is new is the arbitration and mediation legislation third-party funding amendment ordinance that came in 2017. And basically what that does is it carves out maintenance and champerty, or it takes maintenance and champerty and carves out arbitration and mediation. So basically these two offences and torts continue to exist in Hong Kong, but not for arbitration and mediation, which is very good. There is a disclosure requirement, which makes sense. So the funding agreement has to be disclosed within 15 days. And there is a third-party funding of arbitration code of practice, which was issued in 2019. And you can read that. So Singapore also has a code of practice. And I think this is where we're going. There's going to be more codes of practice. They deal with things like materials not being misleading, funders may not influence, conflicts of interest, and then also some kind of annual returns, etc. So these are the things that we're going to start seeing. Kim Rooney, I think, was very much involved in getting third-party funding for arbitration through in Hong Kong. So I think Kim and certain other people in the arbitration community have done a huge amount for Hong Kong, actually. Teresa Cheng also. So typically what happens, and we've seen it now in Singapore, is the law changes, you have guidance, you have a code of practice, but then also the rules of the institutions change. And so the HKIAC administered arbitration rules, the current ones, or the latest ones are 2018. Again, they require disclosure, and that's really international best practice now. But they also talk about the impact on costs. So for me as a tribunal, it's interesting that I can consider that in fixing and apportioning costs of an arbitration. And that obviously also involves the disclosure of the existence of the funding agreement is required. There is also protection of confidentiality in the Arbitration Rules 2018. The other big change that we've had in Hong Kong, and Grace, who's on this call, has very, very kindly shared information issued by the Department of Justice on outcome-related fee arrangements. These exist since 2022, again for arbitration and not for litigation. And this checklist that's issued by the DOJ is very helpful. So we basically have two types plus a hybrid type. We have conditional fee arrangements, so no win, no fee. And you can look at the slides at your own time. We have damages-based agreements as well, so DBAs, the thing that caused the problems in PACAR in the UK. And then we have a hybrid where you can do both. And there are general conditions, and these are reflected also in the DOJ guidance that was issued. And I think they've done a great job. So I think you can read these slides at your own leisure. I think the important thing to note is that there's certain caps. And if, as a lawyer, you want to use these structures, you have to be very careful to remain within it. So for CFAs, the uplift must not exceed 100% of the benchmark fee. That's one cap. And for DBAs, the payment must not exceed 50% of the financial benefit. So those are two caps that I find quite important. Again, please look at my slides, but also look at the DOJ materials. As discussed, confidentiality is an issue, and this is why it's dealt with in the legislation. Notice, again, it's international best practice. It's in the legislation. For outcome-related fee arrangements, it has to be notified. This is also relevant, the part about the arbitrator and costs. So save in exceptional circumstances, an arbitrator cannot order a losing party to pay the costs of its successful opponents that exceed the amount it would have incurred had the successful party not entered into an outcome-related fee arrangement with its lawyers. So this is quite interesting. And this is something arbitrators are going to have to get their heads around, because these systems are slightly different, the rules are slightly different. So these are going to be technicalities and nuances that arbitrators and counsel need to be very familiar with. As mentioned, in investor-state arbitration, things have been moving, and I think Singapore was actually ahead, and now they're behind slightly in this. ISDS is under attack, obviously, and there is a UNCITRAL working group committee, working group 3, and they basically recommended several things, which basically have been done. So I was looking at this in 2021, I think, and the ICSID changed its arbitration rules in 2022, and they basically required disclosure of the name and address of non-parties. So basically disclosure is best practice now. And they've gone a little bit further, which I find quite interesting. So again, you can read this at your own leisure and then maybe compare and contrast with CX commercial arbitration rules that are currently under consultation, and just see whether you think things are going far. I mean, my view is that third-party funding has to be disclosed, but whether the details of the funding need to be disclosed or not is another question. So where I think everything is going is, I feel like we're starting to look at a convergence of rules internationally, possibly, but with certain nuances. And I would caveat that with the point that whenever there's a scandal, there is a reaction. So it may be that there will be scandals in some jurisdictions and stronger reactions than others. In investor-state arbitration, there is a lot of pushback. So maybe that's an area where we will see more pushback. Certainly the disclosure of the existence of funding and the identity of funders is increasingly required, at a very minimum, to allow conflict checks. The bigger question, as just discussed, is what else will the rules and, in some cases, the legislation require in terms of disclosure? There is, as we've seen, basically a best practice starting, that there are codes of conduct for litigation funders, increasing regulation, and I think they are starting to look very similar. So I'd argue they're starting to converge. As mentioned, privilege, confidentiality, there are still different rules. There's obviously a major difference between confidentiality and privilege. And then, as discussed, in America, you have this common interest privilege, which I don't believe exists in Hong Kong or the UK. So there's nuances. And when using funding, this is something that lawyers really need to understand, because otherwise they could end up with disclosure orders against them, disclosing information that might actually harm a case. Whether funding costs are recoverable, and I've taken this from the Queen Mary report, depends on the applicable national laws, or if they don't exist, the procedural rules, early disclosure and reasonableness. So as we've seen, this is now dealt with specifically for ORFSA in the Hong Kong legislation. If there is nothing applicable in national laws or procedural rules, then in general, the tribunal actually lacks jurisdiction to order costs against a funder. Why is that? Because arbitration is basically contractual, and if a funder is not a party to the arbitration, how can the tribunal order costs against a funder which is a non-party? It just doesn't work. Security for costs applications should be determined on the basis of the applicable tests. So that actually can really depend depending what jurisdiction you are in. And it's quite interesting. I do think there is, to some extent, convergence in the test, but there are nuances. Funding arrangements, including after the event insurance, may be relevant to showing a party could meet an adverse costs award. And indeed, I've seen cases where having after the event insurance or even funding is helpful to resist a security for cost application. Another point I'd like to raise, which is maybe a commercial point, is that interest rates are going up. And litigation funders have confirmed to me that what this means is that their costs are going up. It will become more difficult for them to raise funds in the future. And therefore, they can be even more selective as to which cases they want to accept. Also, interest rates going up is putting pressure on companies. It's making it also more expensive for companies to raise bonds, etc. So it is going to mean that funders are more selective, but equally that companies need more funding. So that's an interesting trend. I'm here in this slide just listing some of the funders. There are many others. I have highlighted in bold some of the funders who are present in Hong Kong or in Asia, so you may know about. There's associations, so the ILFA in the States and ALF in England. They are increasingly important in lobbying. So, for example, pushing back on the EU changes, working on codes of conduct, etc. And then you have soft law, and you have hard law. So parliaments and courts introducing regulations, as we've seen in Australia, but then turn around, as we've seen in Singapore, as we've seen in Hong Kong, as we've seen the EU considering. We have legal regulators who look at things, for example, like confidentiality and privilege. And then you have arbitral institutions. So I've just shown you what SIAC, HKIAC, and ICSA are doing, ICC as well. So I think increasingly the institutions will put provisions in dealing with third-party funding. Yeah, so that was my presentation. I apologize, that was a lot of material, but I'm trying to show how everything's coming together. I see there's a question.
Okay. So thank you, Caroline, for a very, very insightful talk. You're right. I think it's very informative because I think you've gone through all the jurisdictions. So if anyone has any questions, please feel free to put them in the Q&A box. But let me see. Maybe if I could start off with, I don't see any questions right now, but maybe if I could start off with the first question, if I may. I wanted to speak a little bit about the outcome-related fee structures for arbitration in Hong Kong, ORFSA. I wanted to, maybe if you could share a little bit about the take-up of ORFSA in Hong Kong, because this is relatively new, right? December 22, I believe. And what would be the key consideration and challenges in taking it up here? And maybe what might, you know, how many, if I don't know if you've got numbers to, maybe you might be familiar with the numbers, and what might, I don't believe there's a big take-up, and what might encourage law firms to offer this for us? Thanks.
Yeah, I mean, I've heard different stories. So I've attended some events where people presented these structures and explained what would have to go into an agreement. And then me being me, I asked them, well, have you done it yet? And they all admitted, no, they hadn't. And so that was interesting. I believe some firms may have been doing similar things for a long time, particularly where they have other offices. That's kind of a little bit in the gray zone. So I think those firms will probably continue what they're doing, but less in the gray zone. I believe that some other firms are very, very conservative. So certainly in the past, most of the firms I worked said, we don't want to do this because it's too, well, first of all, it was illegal. So we didn't do it. But secondly, even in jurisdictions where they could do it, they were quite conservative and didn't want to. But I'm also hearing from law firms that are very interested in and publishing quite a lot. What would it take? I think it takes the right kind of case. And the DOJ guidance that was issued that maybe Grace can share together with my slides, because it's actually really, really helpful, and Grace sent it to me recently. I think it was issued last week during Legal Week. That just sort of spells out what you need to do. And I think perhaps some firms are waiting to see what these kinds of agreements look like, make sure that they don't get them wrong, and then they'll start doing it. But it is, of course, a cash flow issue, because if you take a risk, that means you don't have money coming in straight away, and law firms are businesses, so that's an issue. I personally would like to do a lot more of it, because in playing cards, I play bridge a lot, I'm known as the doubler, but as a litigator, I'm known as a settler. I like settling cases, and I like settling them well quite early. And as a lawyer, that's always hurt me, because we get paid by the hour. My hours tend to be a lot less than they could be if I was doing a lousy job. And so my instinct is that outcome-related fee arrangements could really help me achieve a slightly more fair outcome for myself. So I'm definitely keen on doing it. But I think increased awareness will help. And then going back, there's a question in the Zoom. So how do CFA and ATE work? And I had a slide where I kind of just explained it. I borrowed, I think, from somebody else's slides. I don't know if you can see this, and I don't know if I've taken it away, but there's an interaction. So you can have actually an interaction between third-party funding, CFA, and ATE. And can you see this slide?
Yes, we can. Thank you.
And this is really a point I wanted to highlight. And I think some funders are particularly keen on lawyers having skin in the game too.
That's great. Thank you. Thank you, Caroline. That's a very insightful thing. I think we've got time for maybe one or two more questions. Let's see. I just have got one coming in from Grace herself. She wants to she wants to know whether third-party funding and mediation works similar to arbitration, or if there are any practical differences. Maybe some thoughts there.
Grace, you know what? I haven't studied it, but I think so, because I did see that in Singapore, they extended their scheme to mediation, and I think it's probably the same in Hong Kong. So I believe yes, but I haven't looked at mediation in any great detail.
Thank you, Caroline. Because our audience is also about it also cover mediation, arbitration, and legislation, third-party funding. But so far, when I attend some kind of seminar, I haven't heard about so details about the procedure about mediation. Perhaps maybe maybe the TPF also provide arbitration and mediation service. I'm not so sure in practice whether or whether there will be a trend in other jurisdictions that some kind of mediation institutions will have more detailed guidelines. My concern is about enforcement. I do not know whether the mediation settlement agreements, if third-party funding is involved, would that complicate the enforcement procedures, or it depends on jurisdiction, each different jurisdictions. Yeah.
That's an interesting question. I mean, you know that for mediation, we now have the Singapore Convention, which basically tries to mirror the New York Convention. And Singapore has obviously signed up to that. Not as many, nowhere near as many countries have signed up to the Singapore Convention because it's new. So that's relevant to the enforcement of settlements achieved during mediation. In Hong Kong, if it's an arbitration, I think there's a provision in the arbitration ordinance that allows you to take a settlement from an arbitration and treat it as an arbitration award. So I wonder if it was an arbitration and the mediation was taking place during the arbitration, it would be similar. I just don't know how that works with third-party funding, but certainly my impression, I'm just trying to find the slide, is that in Singapore, it was supposed to cover international arbitration, related court and mediation proceedings, and then it flipped to also covering domestic arbitration. So I'd say Singapore probably yes, and Hong Kong I'd need to check, but my guess is probably yes. I think that's probably the intention, especially if it's a mediation during an arbitration. If it's a mediation during a litigation, I think the position might be a bit different.
Yes, agree. Thank you.
Yeah, thank you. Thank you. Caroline, I think maybe we have time for one more question. I don't see anything in the chat box, but maybe I'd like to ask you to elaborate a little bit about the UK decision, the recent UK decision, PACCAR. Yeah, if you could speak a little bit more. I mean, it's interesting that it may turn the tide of things. So yeah.
Well, I don't know if it'll turn the tide of things, but I think it was a surprise to some of the funders. And like I said, I've seen differing responses. So I've seen a big funder post on LinkedIn that actually it doesn't affect their business at all. But then Tyrium obviously funded an arbitration for Bugsby, and they've won. So they're basically trying to freeze the winnings from that arbitration. And there they were talking about cross undertakings, and I think the High Court is really going to look quite carefully at it. I mean, I met somebody in London who said, "Oh, this is terribly interesting. If these funding agreements fall down because they're unenforceable, they're invalid, then can another funder come in the 11th hour and try and take over a case?" So I think this is going to be quite an interesting development. And I think what it does, at least for me, is underline that when there is a framework like a DBA framework, and like we have in Hong Kong, it's really important for a lawyer and a funder to understand the limits and not exceed them. So you have to play the game within the rules. Otherwise, you could get in trouble.
Very interesting. I'm conscious of time. Thank you, Caroline. I'm conscious of time. I don't see any further questions. I think we can end our webinar today. I'd like to thank you once again for a very insightful talk. I wanted to see if you had any last thoughts and comments before we wrap up.
Not at all. Thank you very much. And apologies, I have a bit of a cold, so I do sound like a frog. Just to reiterate, I will be emailing a PDF of my slides, and hopefully Grace will add the DOJ guidance to that, so you can have those.
That's great. That we'll make sure of that. I've also got a copy of the guidance that we could send through. So I wanted to thank you again, Caroline, for a very insightful talk. I think you've lined up all the jurisdictions very well, and certainly I believe the chronology helps us with our understanding of third party and ORFSA. And I think this is a space for us to watch carefully with all this recent being late in the game, but hopefully it will be an interesting development over the next years. I also wanted to thank our audience for dialing in, and we would appreciate it if you could complete the questionnaire at the end of this seminar, because your feedback helps make these talks more meaningful. And finally, just a plug for our next talk, which is up in December. So we hope to see you there. We have one coming up in December and one in January before it ends this series and we move to our next series. So thank you everyone for dialing in. Thank you once again, Caroline. Thank you, Grace. Thank you, Tammy. And until next time, bye.
Thank you all. Bye-bye.
Grace, are you there? Thank you.
Yeah,
Great.
thank you guys. I think it maybe was TMI.
No, I thought it was good. I actually think that the way you've done it, Caroline, helped us pull it through and understand it. I haven't actually done a talk this way where you've gone through the chronology, and it's helps a little bit, I think, in setting it out.
Well, thank you very much. And yeah, lovely to meet you, and hopefully meet you in person soon.
Yeah, that'll be great. Thank you, Grace.
Thank you, Tammy. I haven't met you, but I think you've done a lot of work behind the scenes.
Thank you for Caroline and Saniza for hosting this seminar. I think the alumni and other students will be benefit a lot. Thank you so much. Bye bye.
Bye-bye.
See you.
Bye.